All righty, and welcome everybody to, well, it's the first for this year, I think, isn't it, Stace? The
It is.
Insolvency Bites special episode for the bankruptcy options paper, just when we thought there couldn't be anything else that could come out of the woodwork. We'd like to welcome everybody this morning. Thanks for joining us for this special edition of Insolvency Bites. I'd like to begin by acknowledging the traditional owners of the land from which we're presenting today and to pay my respects to elders past and present. This morning, Stace and I will be discussing the Bankruptcy System's options paper that was released by the Attorney General's Department in January of this year. We're happy to take questions if you want to pop them in the chat. If we can answer them, we will try. If we can't, we can take them on notice and attempt to come back in future episodes of Insolvency Bites. So the options paper really looked at three areas within the bankruptcy system, and they're not areas that haven't been addressed a number of times previously. So it's look at, again, reducing the period of bankruptcy to 1 year, promoting debt agreements and targeting untrustworthy advisors. So I think the main thing that we'll talk about today is reducing the period of bankruptcy to 1 year. But we do have an hour's airtime, so you never know, we might get around to having a chat about the other topics as well. So I guess, Stacey, the first thing I really wanted to have a chat about is, given everything that we've been through in the last little while, do we think that there's actually more room for change in the insolvency landscape, given everything that we faced recently?
You sound a bit tired. Am I sensing some reform fatigue?
Well, didn't we? I think we started talking. We had the ILRAs come back in 2017, I think it was. And that was supposed to be the biggest change. You know, don't expect anything further. Here we go. See you later. And then here we are.
Yeah, and it was a big change, those reforms, and the staging of the reforms as well made it already seem a little bit drawn out. But you're right. There's been so much going on in the industry from the perspective of professionals, like lawyers and accountants, and our IPs, our registered trustees and our liquidators. So the industry feels like it's also in a bit of a state. There's so much going on. We've been poised for this insolvency tsunami for at least 18 months. I mean, that exhausts everyone, being on edge. And now, you know, we hear murmurings all the time about increased ATO activity, again, for at least 6 months, dare I say 12. But it's just so uncertain. And now they're throwing this in the mix. If it was the first time we had seen it, as you say, this was on the table on and off over the last few years, then maybe we would approach it a little bit differently. But I actually just don't think it's the right time. I know that the industry submissions, the responses initially, and in particular since COVID, has been that, you know, there's overwhelmingly been the view that this should not be reactive to the pandemic and to COVID-19. We need to have that long-term focus. This is not a quick fix, and, you know, the pandemic is not going to last forever. I feel fairly confident in saying that. So I think we need to be careful with submissions and whether any reforms, if they do come about, will suit a post-pandemic landscape. So I think your question's a good one. Is now the right time to usher in these changes, irrespectively, having, you know, how they may look ultimately? But is it just me, or it feels a little bit like the boy who cried wolf? Oh, it's these reforms again. Okay, let's see if they really go anywhere. Let's spend time making submissions again, and let's see what happens. So, the timing's a bit odd.
Yeah, I agree. And this is actually the third time, I think, since 2017 that we've been asked about 1 year bankruptcy. So whilst, and they say it, I think, quite blatantly in the options paper, they talk about the 2021 consultations that the government put out there to inform the ongoing response to the COVID-19 pandemic, which is what you were talking about. And I think there was an overwhelming response that said, don't do anything short term. We saw what happened in terms of the small business restructuring reform and these sorts of things that were happened, you know, very quickly and without any deep consultation at all. and how that doesn't appear to necessarily be the panacea that we thought it would be. Well, not anything we thought it would be, but the government thought it would be. So I think after that, industry definitely said, please don't do it just for that. But this had been brought up earlier. There'd been, pre-pandemic, there'd been a lot of submissions, there'd been a lot of commentary in relation to how that works, how a 1-year bankruptcy would work, a lot of concern around that. Then what happened was it lapsed when we went into the 2019 election. Now, I just find it really interesting, given that we are on the verge of another election, why this is something that's looking to be put up now. For mine, the timing is really quite curious around that. Because if anything...
Curious? Cynical.
Cynical. So definitely, I think that's a really interesting point too. Like, by all means, in a new government, if this government gets back in and raise it, then let's look at it and really sort of ventilate the issue. But doing it now, so close to what needs an election that needs to happen, seems quite unusual to me. And we'll talk about the debt agreement stuff a little bit later, but for mine, that's the same thing. So when 2017, we spoke about, or we were asked about, the 1-year bankruptcy and then some reform around debt agreements. And the debt agreement stuff actually got up and it changed. And now what they're asking us now is, shall we change it back?
Change it again.
And it just is really quite bizarre in terms of, are we changing for change's sake? And really, if it's not broke, do we need to fix it?
Yeah, and I mean, we can get into the debt agreements. So let's get into the debt agreements later. I've got some comments on that.
No, that's absolutely fine, and as do I. So we'll do that. So I guess if we're looking then to the decrease of the bankruptcy period to 1 year, it keeps getting raised and keeps going away. Do we think that it is a good idea? Stace, what do you think? Do we think that a reduction in the period of bankruptcy is a good idea? And what do we think has stopped the take-up so far?
I think that my view of it is very much from a professional perspective. So it's not going to necessarily be shared by the common or the majority if you go out on the street and ask the layperson. But there are some aspects to it that I believe make sense. But to be upfront immediately on my view, I am not an advocate for a 1-year bankruptcy. I just don't think that it will achieve what they're setting out to achieve. From day one, when this all started floating, it was, let's not do any, or let's remove something that might be hampering the entrepreneurial spirit of, your typical Aussie, which is just not a good enough reason as far as I'm concerned. And plus, I don't see that. No. I see repeat offenders, but that's because of the industry that I am in. And that's why I wanted to start by saying my perspective is one from a different informed position.
And can I just stop you there? Sorry, because I think that is very, I think it's a very important point. And obviously I see it from the similar area that you see it from. And people do look to registered trustees, what's going on in the, in the, not industry, but sort of in the, the ecosystem of insolvency around bankruptcies. What are you seeing? Who's going bankrupt? What are the different characteristics of bankruptcies? And I think just at this point, it's really important to point out that the vast majority of bankruptcies are consumer bankruptcies, and they are actually administered by the official trustee at AFSA. So registered trustees, sort of such as me, we only get, as a collective, maybe, if we're lucky, 20% of those. Wow. So there's 80% of that ecosystem we don't see. So I make a point these days of actually talking to some financial counsellors and these sorts of things, especially when we're looking at submissions, because I do see things very strongly from one perspective. But you're right, it relates only to one subset. So I just thought I'd explain that in terms of how we see things, but what we're seeing may not necessarily be reflective of the overall bankruptcy ecosystem.
Yeah, I think that's such a great point, and it really does clarify that perspective that we have. So, and it's nice to hear it in that, that 20%, 80%, because that's actually a bit of a mind reset for me as well. It's like, okay, so I really should be thinking before I take. I still have this strong view. I still don't think it's necessary. Let's just leave it as it is. But, but because from my perspective, the ones that we are dealing with are the ones that, you know, this system really is for as well. And that's why the government goes out and they ask for submissions from a cross section of the industry and the lay public. And, you know, it's not just us that are providing submissions in response. So it's an involved process, and I appreciate that there are lots of different views and conflicting views to mine. But the things that I think about, you know, I mentioned that entrepreneurial issue, which I don't put enough weight on to sort of usher in a change like this. Removing the stigma of bankruptcy is another thing that floats around as a pro to reducing the term. Obviously, we need to always be mindful that a trustee in bankruptcy is still collecting the same income contribution period and still able to investigate and recover voidables and the like. So it's almost like the reduction in the period is for appearance's sake. Does that, if that makes sense? Which is nice for, you know, your typical Aussie individual who has had a series of misfortunes, and it's for those ones that I do feel for. And I have a lot of clients that have been forced into bankruptcy because of the pandemic, or because there's been a major decline in a particular sector, or things beyond their control in the construction industry. And for those subcategories, you're like, yes, it would be nice for them to have that option. But those particular individuals facing bankruptcy are also the ones that are more likely to be able to utilise your personal insolvency agreement, your debt agreement, dare I say, or a Section 73 proposal after the bankruptcy is commenced. So there's ways to deal with it.
No, I think that's right. And there is so many different avenues in the Bankruptcy Act to deal with different situations that it sort of seems quite, a little bit over the top to keep putting in different options, and similar to the corporate situation, I must admit, let's just put this in now because it seems to be a band-aid to fix a certain subset that we're seeing now. But realistically, we're not quite sure where it's going to end up when we don't need that anymore. And I think the longer term view is really important. I'm just wanting to pick up on a couple of things because I agree with the vibe of what you're saying there as well. So promoting entrepreneurship. So this was actually, I think, originally called, and bear with me, the Bankruptcy Amendment Enterprise Incentives Bill when it came out in 2017. And it was around, there was this big promoting startups, promoting entrepreneurship, and why the stigma of bankruptcy, as you're saying, maybe is putting a little bit of a dampener on our business, innovative mindset as a country. So just to that, business-related bankruptcies at the moment, and we know that where we're sitting for the last 12 months is really not representative of where we have been, given the numbers that we've been working with, but business-related bankruptcies account for less than 40% of overall bankruptcies. Now that's, as I said, I think for the last, that's the last quarter. If we went back to 2017, it was less than 30 because I did a submission to the 2017, it was less than 30% at that point in time. Now, there is no strict definition of what's a business bankruptcy. I think AFSA takes the statistics from the ticking, what led to your insolvency, your statement of affairs or the bankruptcy form.
Not always particularly reliable, but yes.
No, well, that's exactly right. But also, business-related bankruptcies can obviously relate to the sole trader and the partnerships and those that are going insolvent. And that's what we think of, I think, when we talk about business bankruptcies. But it's important to note that I would consider, in my experience, the vast majority of those business bankruptcies would be as a result of personal guarantees that were offered through a PTY Ltd company. So it's really not the bankruptcy system that's causing the lack of innovation. It's the restrictions that are put on business people operating through, and it's very rare these days that someone's starting up a decent sized venture that's not in a PTY Ltd company. I mean, it is, the gig economy, and there are people out there just operating under an ABN, I understand. But the vast majorities will go and set up, especially when there's some substance to their business, a PTY Ltd company. And it's at that point where suppliers are offered personal guarantees. It might be a DPN, a director's penalty notice, as a result of unpaid tax in the PTY Ltd company. I don't believe that all of the issues around the promotion of innovation and business and entrepreneurship occur at the sole trader level. So I think that's just an important point to raise as well. So what's the problem that we're fixing?
Yeah, that is definitely a point, a great point.
And to the other point, in terms of stigma and also, looking at the entrepreneurship, it's not the Bankruptcy Act that makes, the 7-year reporting on your credit record. That's not something that is dictated for by the Bankruptcy Act. That's the credit reporting agencies, and there's other, as I understand, codes and guidelines there. So if you're wanting people to be able to turn around quickly and obtain credit quickly again, I would suggest that there needs to be some ground roots change in terms of how our credit reporting is. We are listed now on the NPW, the National Personal Insolvency Index, forever. So once you go bankrupt, that's there forever. Now, someone would have to search that. And I don't think, it's not as though someone's going through every day trying to figure that out. But you are asked, basically within a 7 to 10 year period, you're asked, have you been a bankrupt if you apply for a lease or some other sort of credit, trying to get a car loan? It's the asking and the responding to those questions, I think, is probably more of an issue as opposed to the actual period of bankruptcy. I don't know if you have anything further to say on that.
Oh, I think that is such a pertinent point, because that is one of the most commonly asked questions. By the time I speak to a cross section of people. I do a lot of free consultations with people in financial distress that doesn't go anywhere for me. It's the case that they can't afford a lawyer, and I just give them some guidance. But and then of course I have my paying clients, which is nice as well. Irrespective of who it is, they're not querying the 3-year bankruptcy period. They want to know, can they get a home loan in the future? Can they use their credit cards? Not during bankruptcy. All those sorts of things. And how long will this stay on my credit rating? They're the big issues. And for those that coming on that flip side, once they're through bankruptcy, it starts again. It's like, I know we've talked about this before, but is there any way to get this off the NPII? Is there any way for me to remove it from my credit report? What can we do about this? So you're right, that hasn't come up unless I've missed it. Presumably there'll be some submissions made about that by some of our more savvy industry specialists. Thanks, Alice, because that's a great point. Great point.
Thank you. I think the other thing I just wanted to raise, and it probably goes back a couple of points, but when we're talking about, the 2017 submissions and then the 2021 submissions and now the current submissions, it's important to note that I've probably been in this industry now a bit over 21 years. And just before I started, there was an early discharge provision in the Bankruptcy Act, where bankrupts could apply if certain circumstances prevailed to be released earlier from the discharge from bankruptcy. And that was removed with a lot of the amendments that came through in the late 90s or the early 2000s. We still had a couple of sort of really old tail end bankrupts that could have applied if they wanted to. But my understanding was that was removed because it was too complex. The criteria that was there related to such a small subset, so that it wasn't really applicable to the vast majority of cases that were there. And also because it was just, no one was using it. So it's, again, really interesting just to even take that step back one step further to say, well, we did have something that was there. It got taken away because it wasn't being used. now we're trying to reincarnate again. How can we do that, in a way that may be helpful to all stakeholders? And I think that sort of leads me on to our next point, where we wonder whether what could be helpful in achieving that reduced period of bankruptcy that could appeal to all stakeholders. I think for mine, it's a balance of responsibility, but without onerous punishment.
Yeah.
So I think the incurring of debts, is something that's serious that needs to be taken into account, because that's generally someone else's livelihood. People think sometimes that we're incurring debts, it's a big organisation, doesn't matter if we don't pay them. There's a sort of interesting mental sort of scape around that and how that works. But when you've got, mum and dad suppliers, you may have other, suppliers or customers that have put down deposits or these sorts of things. And it really does affect genuine people if people don't pay their debts. It's a serious matter, and it does need to be taken. I think the responsibility of that needs to be taken into account. But on the other hand, we do use bankruptcy as an alternative to a debtor's prison. So we aren't looking for something that provides, onerous punishment that's not, it doesn't have a comparison to the action. It's got to be something in the middle. And I think where we've been operating with the 3 years seems to be about right, in my experience, in terms of it's not just I'll sign the form and then tomorrow I'm back on deck doing it again. Exactly. But it's also not, whilst it's on the NPAI for a year, it's not something that needs to be brought up constantly, 7 years hence. So I think that those things are interesting. I think that as a country in this sort of economic space, we're suffering from a bit of identity crisis. I think that, historically we've had this, by nature of, our country and how we're governed, we have this throwback to the colonial or the UK system, or the Westminster system of law, and we follow quite closely in terms of our bankruptcy and insolvency from there, which does seem to be quite sort of, I don't want to say draconian, but there is a certain level of punishment, and you need to pay for that, and we need to make sure everybody's taking responsibility. But we seem at the moment to want to couple that with the American view, or the view in the US, which is very entrepreneur-based, which is very, there's not a lot of stigma. It's often been said that you're not, a real business person unless you have been bankrupt if you're in America. But it's important to understand that there are different provisions as well. So, in terms of whether or not you can keep your house in America in a bankruptcy situation is vastly different to the situation here. Also, the ability for secured creditors to prove for the sort of unrecovered deficit in their loan. So my understanding is if you're bankrupt or you're insolvent in the US, you can basically walk out of your home and you're not necessarily on all, in certain circumstances, liable for the shortfall. If they sell that.
Okay.
Yeah, so if you hand I can't pay my mortgage anymore, and I hand my keys back to the bank, not that that happened, but if that were to happen, and the property at that point in time sells for less than the mortgage value, there is still an outstanding amount that the bank can pursue, the individual form. My understanding is that that's not the case. If you go and say, okay, I can't pay anymore, here's my keys, you're not left with that tail of debt behind you. So there's certain elements there that don't apply here and vice versa, where I think we're trying to have this entrepreneurial, destigmatized bankruptcy system to replicate that, but not playing in the same sort of eco space that they are. I'm sorry if that was a little bit confusing and all over the place, but I do think that that's a really relevant point to raise.
Yeah.
So I think, if creditors want to get paid, they will continue to put in place precautions so that they can. Things like the personal guarantees we were discussing earlier, things like checking credit reporting and having strict terms and conditions around who they will lend credit to. I think that that's the side that will, we need to understand we need to protect the creditors so that they lend the money, so that there is a commercial environment within which to work, but at the same time not punishing too harshly,
Yeah.
the debtors who at the end of the day can't repay their debts. I'm probably all over the joint. Do you want to try and talk about
I know. I hear you. In terms of, how we can make that reduction in the period more attractive, or deal with various stakeholders' concerns around it, I think the options paper, and we should put a link up as well after this for everybody, but it goes some way in doing that, I think, by proposing that increase or strengthening, I should say, of the objections to discharge provisions and the offence provisions. So these are workable theoretically, and they're workable in relation to that subset of individuals that perhaps are trying to work the system a little bit, or I don't like to refer to them as the bad bankrupts and the good bankrupts, but the ones that have been working the system, or have taken advantage perhaps of certain creditors, or entered into transactions, committed offences, let's just say that. So they're strengthening those provisions, or at least proposing to, under this options paper. So I think theoretically that goes some way in alleviating those concerns. I still have a view that it doesn't go far enough, but I'd be interested to hear your thoughts, Alice, from a practical perspective, sitting in the seat of the trustee. So how will that work? Is if there are strengthening of these objections to discharge provisions, and also the offence provisions, is there then an increased onus on the trustee to action investigations into offences immediately, which, they generally do anyway, I'm sure. But will objections become more common because the trustee, as soon as there's some inkling that there may have been an offence, or there may be something to look into further, they've got to get that, lodged with AFSA ASAP. So from there, we've got an increased workload on AFSA. And, what does that mean for AFSA, and what does that mean for us as industry professionals? I have no doubt that there'll be different schools of thought around how effective AFSA can be at times. Do we want to be increasing their workload? So what does this all look like in reality? I mean, what do you think about that?
It's a really interesting one. I think in terms of offering a certain level of theoretical support, I think that's, where they're looking here. I think, so just looking at it practically, I am a fan of the objections to discharge regime, probably over the offence referral regime, and I'll tell you why. So objections to discharge, there are a certain level of things. So we should tell people, so currently people are bankrupt, individuals who go bankrupt are bankrupt for 3 years from the date that they file their statement of affairs. So that can be the date that they make themselves bankrupt, if they're doing it voluntarily, or it can be the date that they file their statement of affairs if a court order's been made to make them bankrupt. If that's the case, the bankruptcy doesn't start until that document is filed. So I think that's really relevant to point out. And in the situations we're talking about, that 1 year won't start either until that document's filed. Now, the bankrupt should be automatically discharged from bankruptcy 3 years after the filing of the statement of affairs, the date it's accepted with AFSA. But the trustee can lodge an objection to discharge on a vast number of grounds, which would then have the impact of either extending the bankruptcy to 5 years or 8 years from the date of the filing of the statement of affairs. That's not a set down locked 5 or 8 years. It's meant to be an encouragement. So one of the things that is most often used is a bankrupt is required, as you alluded to earlier, Stacey, to basically notify their trustee of their income every year. If they earn over a certain amount, that there is 50% of the surplus is to be paid to the estate. One of the biggest, non-compliance issues we see is that we just don't get told what the bankrupt's income is, and we need to write to them, and we give them a questionnaire, and then they tell us what their actual income was for the past 12 months and their proposed income for the next 12 months, and we ask for information such as bank statements, tax returns, etc., that go with that, so we can do that assessment. So the vast, majority of non-compliant positions that we see bankruptcy in is just not providing that information. So if that happens, we can lodge an objection to discharge, which says, okay, now you'll be bankrupt for 8 years, if that's accepted. Now, a lot of the time, they still won't do anything until they come back to us after the 3-year period and say, oh, now I'm discharged. And say, no, you're not, because you didn't do these things. And so now you're not down to be discharged for a further 5 years. And at that point in time, it can sometimes come as a shock, even though we're required to serve them with information advising them of the discharge and certain hardship provisions and these sorts of things. But we work with them then. And a lot of the time, it's surprising how quickly all of that can get bundled together, given to us, and then we take it off. So it's not sort of an arbitrary, now it's 8 years, you're there, doesn't matter if you do the right thing or not, but it provides an encouragement for something to happen. And I think that is really valuable, because people, I don't think, want to be bankrupt longer than they are. So they will comply. And there's, a certain number of things in terms of disclosing, different information or providing us with documents that can fall into that regime. So I think that's quite good. I think what we're seeing...
Can I interrupt you just quickly with a thought then? Really, it incentivizes them to do the right thing. So they've gone from a 3-year period, which they've reconciled in their head. They're resigned to it. I'm just going to work it through it. There's an objection to discharge. They realize there's another 5 years. All of a sudden, and I see it too, it can be really quick. They're incentivized to do the right thing, comply, work with their trustee, and it is done. So on the flip side, are we disincentivizing individuals to do the right thing, to work with their trustee by reducing the period from 3 years to 1? It's, there's an analogy there that we can look at and sort of draw some guidance.
Absolutely. I think that's really relevant. And I know I'm jumping around a little bit here, but I know that there's a number of organisations and submissions who have basically just flipped it around and said, why not let the trustees apply? If on the request of the bankrupt, if there's a certain amount of debt, or if then there's a level of compliance and it's unlikely that, there's going to be any income over the period, but obviously the provisions will still apply potentially, why not let the trustee say, this one seems like a prime candidate? Despite popular opinion, we don't want bankrupt estates hanging around for 20 odd years, as some of them do. We'd rather get them, process them, do the administration of the estate, and then, file them and finalise them at that point. So if we can do that earlier, and we can understand, in a number of cases that there's not much in it, then that would then again incentivise. Well, if you give us everything and we understand that position, we can apply so that you maybe can come out after a year as opposed to staying for 3. So, and I think that's a really valid point. If we look at some of the proposed provisions to strengthen the objection regime, you'll notice that they come from a number of the grounds of offence referrals. So something like, notifying of a change in name, address, daytime, that's not been an objectionable offence before, but it is an offence. It's actually a really difficult offence because, as quirks would have it, even though we know that somebody's no longer at an address, if we don't know where they are, we're told that they can't be prosecuted because we can't prove that there has been a change of address. So in terms of practicality, it's actually quite difficult to pursue prosecution, even though there's some really strong offence referral provisions in certain situations, just because of the actual evidentiary requirement for those. So pulling those into the offence regime, I think, is a fabulous idea, irrespective of 1 year bankruptcy or not, because again, it encourages people to comply as opposed to punishing them for not complying, where really can we punish them anyway because we don't have the evidence. So I think my view is strengthen offence provisions, sure, and I think that's mostly around increasing potential periods of jail time, that sort of thing.
Yes.
Yeah, exactly. So understand that. But if we can't get there to start with, is increasing the penalties really going to be helpful? I think that's a question that could be answered. But I do think that strengthening the objection to discharge provisions is a great idea. The only issue is if it's 1 year, to be honest, by the time, and things take time as trustees, and we all look at the tax office, for example, and we understand the tax office has a 28-day charter in terms of when they get back to people, and how long they have to process information. And that's the tax office. So, day one of a bankruptcy, and we get the statement of affairs, and we write to the lawyers, and we write to the accountants, and we write to people to say, can you give us information? Let's say they do give it back to us straight away. That's already, a 1 to 2 month period that's gone. Then it's reviewing the information that's come in, if it's come in, making further information requests to third parties or otherwise, and sometimes that needs to be via the courts. Sometimes it's not something that we can just get in terms of a trustee notice under 77A, or we might have to get AFSA to issue a notice under 77C. That takes time. It can take 3 months to get something like that issued. Now, that's very quickly eating into your 12 months period of time within which you can lodge an objection to discharge if the 1 year bankruptcy comes in. And it's not just if we get information back or not. And sure, we can, lodge objections on that sort of ground, but maybe it's not the bankrupt that we're after to get the information back. And it's not until we've had information from the banks or the advisors or the ex-wife or the family or whoever it is that we can then assess it and then identify if there is a reason, a line of investigation, a line of recovery, or a line that we need to object. So realistically, 1 year to look at all of that, and we have to submit the objection probably a month early to make sure that it actually gets submitted and on the NPII before the automatic, because it is an automatic date of discharge. So the period within which the trustee has, to deal with those matters is quite slim. And I think, again, whilst we're only talking about a small subset of bankruptcies, understanding that, the consumer bankruptcy with AFSA, the vast majority, it applies a significant amount of constraint, I think, upon the administration of the estate.
Yeah. And exactly why theoretically it sounds good, but in practicality, how is that actually going to look? And this is coming from you. So your perspective is as a private registered trustee. How is the official trustee going to be dealing with this? Because in my experience, my private registered trustees tend to move a little bit quicker than the official trustee in AFSA. So, I think there's issues there. I think
so. Just to raise that, and just to get everybody in the same mind, we assume people know, what we understand and how things are working in our ecospace. So at the same time as this happening, AFSA is doing a lot to try and ship out estates that have any great, issues within the administrations to registered trustees. So there's been new regimes brought in just in the last 12 months, whereby it used to be that AFSA would get the bankrupt estate if you file it voluntarily without a consent from a registered trustee. AFSA would get that. They would assess it. If, following the acceptance of that bankruptcy form, they thought that there might be an issue such as a legal action or a property recovery or something similar, they would then request that it be transferred to a trustee, a private trustee.
And what's the timetable around that, Alice? Like how quickly are they doing that? Are they
need to then, well, this is the thing. And sometimes it's not until they realise that there's an issue that it then gets passed on. So there's a new regime now whereby they can look at it before it's accepted and request that a registered trustee provide a consent so that from the outset, they are the trustee of that bankrupt estate. And that seems to be working okay. Although it means that there's more work coming out to the registered trustees. I'm not complaining by any stretch, but some of it is, there's probably not the issues that initially, the official receiver has seen in those files to come out. But there are still matters, and I only got one this week, where I was made aware a month ago, so that it may come across to me. They then needed to report to creditors to see if there was any objections. and that's come to me now. Now that bankrupt estate started in November, and I got the estate on the 17th of this month. So that's a very new estate to me. It's not too bad, but when you think about it, I would then have 9 months to try and establish, what needs to be done.
You just ran through, yeah, exactly.
Yeah, so I just think it's important to understand that whilst a year, it's a year, it's not really a huge amount of time in the practical scheme of things.
Yeah.
So when we're looking, though, one of the things I do need to commend the Attorney General's department on in relation to this paper is they seem to have listened to a few things in terms of the waterfall effect and concerns around recurring debtors. The fear with the 2017 changes was that you'd have someone, they'd file for bankruptcy, a year later they'd get out, then they'd go again, and there was no security around how to stop that happen, preventative measures in those submissions. Now we're looking at a waterfall effect, which I think is actually quite good. I'm relatively supportive of, and it was something that I raised in our submissions in 2017. So the Canadian system does have a waterfall effect. It's not, so what in Canada, you basically, I think it's 9 months for your first bankruptcy, unless there's surplus income or something to go in. So basically 9 months. Then the second bankruptcy is 24 months. And then if you go bankrupt 3 times, you have to go to court to get discharged. So that's the Canadian system as I understand it. The waterfall effect that's been put forward in this paper is basically that 1 year bankruptcy is not available to individuals who in the last 10 years have been bankrupt, have been banned as a director, have had a bankruptcy extended through objection to discharge, or have been convicted of certain offences. So my understanding is that then, depending on how many bankruptcies, it can be extended to 2 or 3 years. But then after 10 years, all bets are off. You can do the 1 year bankruptcy again.
You start again.
I think that's fair enough. What are your thoughts on that, Steph?
Yeah, look, I think it's, again, in theory, I think it looks good, and it's a solid answer to, it's probably some of those early submissions, and it's good to hear that you sort of picked up on that back in 2017. It still strikes me as messy, and I would prefer, when I was first reading this a couple of weeks ago, this newest options paper, if we went back to that older regime of, well, why don't we just enable provisions where there can be an application to reduce the period after the fact. So rather than trying to go through this whole process at the start or the commencement of the bankruptcy period, and again, I'm not quite sure what it looks like in reality, in practical terms. Is there a certain boxes to tick that says, yes, I've been bankrupt before, or yes, ASIC has banned me as a director on X number of occasions. That's all happening at the commencement of the bankruptcy period. So, your timeline of events that you just ran through before, Alice, in terms of everything that needs to get done in that first 12 months, there's a few more little investigations that you might need to be undertaking. And, it's important to flag that, sometimes you're dealing with individuals who have had advisors that might fall into that untrustworthy advisor category, which we'll talk about in a minute, or their former advisors, because they weren't getting paid for their services for the few months before bankruptcy, and they're not feeling very cooperative with the trustee or with the lawyer acting for the trustee because they haven't been paid. You just don't know. But, I digress a little bit. It's what does it look like in reality? And I think that when I was reading through it the first time, I was like, oh, okay. And I was like, well, who's going through all this? Who is monitoring this and going, okay, well, you qualify for 2 years, but not 1 year. And, if you just wait another 12 months and don't go bankrupt, can you hold off your creditors for a little while? There's, in practical terms, there's some issues there. And that's why I think that if we did it at the back end, or if trustees were advising their bankrupts, or they had, a trusted lawyer or accountant who was across these provisions, should they look at it enacting something like this again, put in front of them, these are the grounds upon which you can apply for early discharge. 3 years, but there's provisions which enable you to apply. And I just think that is a simpler and neater way to go about it.
Oh, I couldn't agree more. I think if we had our pick, that would be it. The way I see it is it's like the answer that nobody wants to get. And so we just keep coming back and asking again. Should we do it?
That's right.
What's for dinner tonight? Roast chicken. No. Can we have nuggets? No. Then I could come back again and ask the same thing. It's like, no. I think most participants in the industry, from a registered trustee or a legal point of view, people who are sort of on the coalface looking at those more complex, not necessarily consumer-based bankruptcies.
Yeah.
They're making the request, making it not an automatic 1 year, because that's the thing. It just happens without anybody, knowing about it.
Then on top of it,
yeah, I think that's the clincher, and that would be the list, the list ticker for people to want. If we don't have that, I think that's why we're going through all of the questions time and time again. So I couldn't agree more with you on that. Do you want to skip forward and talk about the untrustworthy advisor stuff, or would you like to go through the debt agreement stuff now? The debt agreement stuff's next in the paper, but we have been talking about
let's talk about untrustworthy advisor activity.
All right, we can do that.
It's I'll let you lead in.
No, that's okay. So basically, there's certain proposals that have been put forward in the paper to try and target untrustworthy advisors. And, this is the name that we've been using for some time now, because everybody's been...
I've been using a different name, but not appropriate.
It's hard. As you said earlier, it's important for debtors to understand their rights and their obligations. With, it's the stringent reporting requirements of trustees in bankruptcy in terms of what we can offer by way of options and initial consultations and those sorts of things, it really is a position that we now can't necessarily look at a certain set of situation or certain set of circumstances and advise on what might be the best way forward, because conflict says that we may then be assessing on that, or adjudicating whether that's a valid way forward if we were to then become a trustee of that estate. And so those things should be separated. So the issue has been that the people that then are offering those services aren't necessarily always regulated. They sometimes don't have qualifications. They're often uninsured. And so whilst the debtor, I think, many times is genuinely trying to do the right thing by looking, getting someone to act for them. The first thing we say when we go into doing an advice or looking at options is we don't act for you. If we go in as a trustee in bankruptcy, we have to report to all stakeholders. Creditors are sort of, if it's definitely insolvent, creditors are the number one. We need to identify, how things work. So, understandably, debtors will want someone to act for them and to have their best interests at heart. And we would hope that often that's the lawyer or the accountant that's involved, that we may be speaking to peripherally. But sometimes it's not. And there's a lot of options out there now for people to go and see, pre-insolvency advisors, some of which, are absolutely legitimate. Some of which are also, trustees and liquidators who aren't necessarily the ones going to take on that formal appointment, but can offer, fee for service work. But some of them aren't. And I think that's where we have some issues at the moment in terms of trying to dissuade the use of those untrustworthy advisors. So the Attorney General's office has put in some suggestions in terms of targeting untrustworthy advisors. And they basically say the government's considering strengthening the detection of the untrustworthy advisor activity and introducing new offences. So what they're wanting us to do is, and they've started this a little bit, but they're wanting trustees to ask the question as to whether or not, that has been advised, or by way of our investigations, understand whether there's been a an untrustworthy advisor consulted in the lead up
Yeah.
and offer that information back to AFSA. You'll see at the moment the Form 12 consents. So when someone takes on, a private trustee takes on a bankruptcy, you need to fill in a consent to act form to say, I'm prepared to act as the trustee of this estate. I don't have any conflicts. Now, only recently, last 6 months, there is a form fill there that actually says, unless it's a 181A transfer, who referred you the job? So, for a lot of the court matters, it's the client or the solicitor acting for the petitioning creditor. But then if it's someone who is coming from, the acting for the debtor, then we need to put that in there. I think the question is, what are you going to do with that information is the point. It's sometimes coming to you already, but I'm not sure the information is being used. Now, the onus is being put on registered trustees to basically provide information about pre-insolvency advisors, and that requirement will be prescribed in Section 77 of the Bankruptcy Act. Do you think that's going to have an impact?
I think it is I think there needs to be, let me put some context around my answer to that question, because as you said, there's a lot out there that are good at what they do, genuine, and work well with the trustee and with their clients. But this is a real issue, these untrustworthy advisors. There are repeat offenders. And I found that there's just not enough bite in either AFSA or ASIC when you're looking at liquidations and the Corporations Act when dealing with them. So again, theoretically, I think the proposals are great. Let's enact them. Let's strengthen the offence provisions. Let's extend the scope to advisors. But if we are going to do that, there needs to be proper follow-up action. If there are requirements on the trustees to provide information about the pre-insolvency advisors to the Inspector General, great. Sorry, yet another thing for you to do, but
12 months.
Yep, within 12 months. But before we even look at that, what is the Inspector General then going to do about it? Is AFSA going to prosecute? Is there going to be funding available to the trustee or to support creditors throughout the process? So again, we're always looking at needing to think, what is it going to look like in reality? Because, I deal a lot with ASIC through my liquidators and trying to, get funding for prosecutions and all those sorts of things. And it is a process. So if they're going to introduce these reforms and there's no action, or the action is toothless after a referral, then what's the point? The industry is not going to change. So, in theory, I'm for it. I think it's a good thing. I think a lot needs to be done about this. Again, you and I are looking at it from a perspective where we probably see it a lot, and a lot more than, other people in different professions or the individuals themselves are aware of it. But it's a big problem. It really is. And if we're going to introduce reforms that in theory look good, that we need to have the backup, and they need to prosecute.
Yeah, no, I think that's right. I actually think that there's a couple of things going on at the moment that is helping that to a interesting. I think sort of it's not been a designated outcome of certain initiatives, but it is helping. The transfer from AFSA to registered trustees is one of those initiatives, because it's been, and I've seen it a number of times where, there's an advisor who's given advice to basically do X, Y, and Z, but then gives the matter to AFSA because they won't find it in their initial tranche of searches. You'll just get filed and it'll come out the other side. So I think actually shipping off some of these bankruptcies to, third-party registered trustees is causing a bit of a stir in relation to that piece of advice, because you just can't judge where it's going to end up. This seems to be done a bit after having the friendly trustee or the friendly liquidator, because, given things like having to disclose where you're getting your work from, excuse me, having to say now that you've made inquiries and having to disclose that, a trustee needs to understand the value of their ticket as opposed to the value of some of these other relationships. And whilst there may have been a grey area before. I think for most of us there was never a grey area, but where there may have been for others, now it is very black and white. You are either telling this or giving this information, or you are not. And if you are not, then you're in breach of your duties. And I think that puts a light on it such that there are a number of trustees that just won't take that now, which is a good thing, right? Because it means that the systems that are in place by some of these untrustworthy advisors aren't working, because at the other end they don't have somebody to sort of toe the line for that. So I think these things have been positive. The issue that we faced both in bankruptcy and in liquidations previously was that there was never the offence of concealment is that of the debtor.
Yes.
The offence of disposing of property is that of the debtor. Really, and who's the only person that's going to be able to tell you if they've had an untrustworthy advisor? The debtor. So there's been some commentary about whether or not there's an indemnification brought up in certain matters for the debtor to say, okay, you need to tell us who's told you to do this, and in doing that, there may be some sort of prosecution indemnity for the debtor to encourage that sort of information to come forward. Because there's been, I think, ability to like the aiding and abetting offences but that's very difficult. Again, if it's that difficult for me to try and prove that someone's moved address, imagine how difficult it is to prove that a third party who is very sophisticated in these sorts of dealings
it's not their first
aiding and abetting. Exactly, and it's really quite difficult to deal with. So I think it says here that the government's considering adding to the existing offences to make it an offence to advise, instruct, assist or counsel any person to commit or attempt to commit the existing offences. It's expected that these offences will generally contain false elements, intentional knowledge. So I think that's great, and I think it brings us in line a little bit with the corporate side, where we've got now the creditee defeating disposition. So I think that's good, but it's, again, what are we getting? None of this advice is given in writing. It's not as though there's a smoking gun and a dossier of how to do this sort of manual. It's verbal. It's he said, she said. You then have the more sophisticated, untrustworthy advisors generally dealing with somebody who has gone to them to because they don't know what they can do for their own situation. So I'm very passionate about cracking down on untrustworthy advisors. I've just seen really, terrible impacts to people over time, when realistically, if they've just gone down the right path, there would have been nowhere near as much heartache as there has been in their situations. But as you said, there needs to be a bit of bite at the end of it.
Absolutely. I think the sad part for me, and I've seen this more times than I care to, is that it's often the case that they have also, the individuals have given their last dollar to these advisors, and we're talking lump sums in the tens of thousands of dollars. We'll help you, we'll get you all set up, and then you can just go bankrupt, and it'll be a really easy process. We'll put our friendly trustee in, or we'll give it off to AFSA, and you'll be fine. 3 years will be gone before you know it. And then they're calling upon family members and saying, I just need $30,000. I just need $50,000. And that sets me up and we're done. So it's really, really preying on people at their most vulnerable and desperate point. And then for them, when I see them, which, might be as little as 30 days later, it might be after the trustees started probing as they should, and they're like, well, this has not worked out the way I thought, so actually perhaps I do need a lawyer, and they're like, it's just it's mind-blowing, some of the things that they are set up to do, and they think they're doing the right thing because as far as they know, these are trustworthy advisors.
Right.
They say all the right things. They're specialists in the industry. They've got a good track record because they're salesmen. Anyway, I'm probably starting to sort of pick up on your passion as well, because I'm quite passionate about it as well.
I think it's a valid passion.
Yeah, I think reforms are needed, but we need to be making sure that if they are enacted, that they're really heavily prosecuted. If there's going to be a change, there needs to be that heavy prosecution.
I agree. Look, we're running out of time, but do you want to just really quickly jump back to debt agreements, and we can have just a quick chat? I don't have a huge amount to say. The only things I was going to say is, so just so everyone knows, debt agreements are a non-bankruptcy option, but currently still an active bankruptcy to propose a debt agreement. They're basically available for a certain subset of debtor who might be facing insolvency in particular, who owe less than a certain amount, who earn less than a certain amount, and who have assets of less than a certain amount. Now, whilst registered trustees it's within our gambit to administer debt agreements, I don't actually know of any of us that do. There is another subset of debt agreement administrator appointee who can be an individual, but is generally a corporation, which is an interesting, interesting sort of subset. Who can then administer debt agreements. And basically, it's more of a payment over time. It can sometimes be sold as a consolidation of debts, but it is more than that in terms of an actual active bankruptcy. In 2017, when we first started, chatting about one-year bankruptcy, we also were talking about debt agreements because there was a bit of a flavour to them that I think there were issues around how they were being sold, for want of a better word, to the debtor. They could be as long as 5 years. Sometimes, in certain situations, they sometimes extended. And whether or not realistically they were a better option for the debtor than a bankruptcy. And sometimes they are. Sometimes if there is enough income to pay a set amount over a period of time, they can be a good option. But the tightening of those provisions actually came in, and it was a 3-year period. There was some commentary or some regulation around how the debt agreement administrator could get paid. I think historically they basically got paid first before anything went out to creditors, and now it was more of a maybe we should share that sort of risk analogy. And so it really tightened that up. Surprisingly, and I would have thought showing, credence to the fact that those tightening provisions were working, there was a minimisation of people taking up debt agreements. Again, we have been through, this COVID period where there's been limited period people taking up any sorts of insolvency. But for some reason now this has seemed to be a problem, and we're wondering whether we now need to make debt agreements more attractive and extend them back out to 5 years, and adjusting those limits so that more people can take them up. And I can't for the life of me, and I have actually spoken to other stakeholders on this, but I can't for the life of me understand why we would do this, especially when potentially, we were looking at 5 years versus 3 years. Let's think about that initially. We're now potentially looking at 1. So you're wanting to take the debt agreements out to 5 years and minimise bankruptcy to 1. I'm not sure how many people are going to be more positively affected by 5-year debt agreements than 1-year bankruptcy. There is certain circumstances where there's houses with minimal equity and you want to keep their house. And I get that. I just find this bizarre. Stacey?
Yeah. Oh, look, I agree. When you're looking at the options paper, it looks like an undercooked add-on. It's almost like, well, okay, we've got this and we've got this. Oh, let's add something else. Debt agreements, let's throw those in. Just leave it be. There's been a decline in the take-up. The paper actually throws some statistics at you. Have a look. As Alice, you've said, it's obviously greatly impacted by COVID. How much so, I don't know. In a practical sense, in what I do, we don't deal with them. We very rarely even advise, this is a good option. In my experience, the take up on this option is the uncertainty of the creditor position on the proposal as one aspect. But secondly, when you're looking at the other options under the Bankruptcy Act, whether it's a PIA, personal insolvency agreement, or the bankruptcy itself, or a Section 73, I think the attractiveness of a debt agreement, coupled with that uncertainty, because you've got to lodge it with AFSA, and AFSA has to make the recommendation, and the creditors still have to vote. Sometimes it's just easier to go bankrupt or put up a PIA. But in terms of so that's just the concept generally, debt agreements. But I don't think the reforms proposed is necessarily going to increase the utilisation anyway. That's not the issue. I don't think there's anything wrong with the regime as it is, other than it is not more times than not the better option out of the other options available under the legislation. So leave it alone. Stop trying to overcomplicate things.
I think that's a very valid point. And on that note, do you have anything else, Stace, that you'd like to raise today before I
Just a pleasure catching up with you as always. I know it's been a slower start to the year, our first Insolvency Bites, but what a great topic to tackle, even though it's for the 100th time over the last 4 years, because they keep shoving it back under our noses.
I'm sure we'll keep talking about it, I have no doubt.
Let's reschedule this for 12 months.
Exactly. So I think the moral of the story is just to watch the space, wait and see. We'll provide some updates, I'm sure, as we go along through Insolvency Bites. You can follow Insolvency Bites on LinkedIn for different updates, but I'm sure Stace and I will share on our respective LinkedIn as well. Thank you very much, Stace. It's always a pleasure. It's sometimes a little bit too comfortable when I go off on different tangents, but I think that we actually are able to get the best out of each other to be able to do that and really show an honest and authentic viewpoint of where we're coming from. So thank you everyone for joining us today. If you had any questions, don't hesitate to reach out, and you've got Stacey's and my details on LinkedIn as well. Have a great day. Thanks
everyone. Thanks, Alice.